Alex here with part 179 of the My Docket series on child custody and visitation. As in the previous videos, I'll take this opportunity to direct my viewers to part 0 if you haven't seen it yet. That's a video that contains detailed disclaimers and the underlying purpose of the series. Two things that I will glaze over are, number one, I'm not in the middle of this right now. My case is completely and totally over. It's closed. It cannot be reopened, and that's because my ex's parental rights have been terminated. Number two, the nutshell version as to the purpose of the series is to give my viewers one big example of my 8-year-long high-conflict child custody ordeal from beginning to end in chronological order. We go into another motion for supplementary proceeding. I think this is the third one that we are going through in the My Docket series, so I'm probably going to glaze over a lot of it. I don't imagine that it's going to be any different, with the exception that it'll probably reference the Court of Appeals decision overturning the denial of District Judge Chuck Weller's order. So this is in the civil, I think it's in the civil repetition case that I've already won. Even though I am not done with the appeal in the child custody case where District Judge Bridget Robb refused to allow me to do this, I am going ahead and doing it in this case because the basis that the judge used in the other case doesn't apply here. In the other case, she tried to say that my ex had a certain amount of time to send payment directly to me. And that is the basis that she used to commit all of the errors that she did in that case. Until that decision is overturned by the Court of Appeals, I'm stuck there. I can't do anything. This is the other case, though. And in this case, none of that stuff, is prevalent. And so for those reasons, I decided to go ahead and file the motion for supplementary proceeding in this case. And I figured, once I get my ex to appear at a debtor's exam in this case, I can get all of the questions that I need answered in this case, and I can use those answers to collect on both judgments in both cases. So this is me just working around the family court judge's dysfunction to get what it was that I needed to get in the first place. And that's really all that there is to it. My mindset at the time was, for the most part, non-emotional. I just gave up caring what the judges thought of me. I just gave up thinking that the judges applied the law correctly. And so I really didn't have a whole lot of emotion, behind this particular motion. It was just a means to an end. It's a different case. I have a cost award in this case. Monies are owed to me in this case. My ex isn't paying, and so you can try and stop me all you want in FV08, but I'm going to go ahead and get what I want anyway in CV13. And if you want to learn more about that mentality, please watch my video on the topic, Attack, Attack, Attack. All that being said, let's go ahead and take a look at what I have filed. Here we have my motion for supplementary proceedings in the aid of execution. Again, guys, if you really don't like the fact that I'm glazing over this, please just go and find the first, maybe even the second motion for supplementary proceeding that I filed, because especially the first, because that's the one where I most likely go into all the little teeny tiny details as to how debtors' exams work. In fact, if you really want an overarching view of what this all is, you can watch my video Execution and Asset Seizure, because that is disconnected from the My Docket series and just kind of goes into all of the different mechanisms available to you to collect your money judgments. So standard introductory paragraph, I identify myself to the court as the petitioner. I indicate that I am appearing in proper person, which means I don't have an attorney. And in this case, I really don't. My attorney, my friend who's representing me for free in the FV08 case, is not representing me in the CV13 case. And that's what I wanted. I wanted to maintain full control of all of my other cases, including the appeals. I didn't want her to make any appearances in any of these cases. Factual background. So let's see. I identify the March 24, 2015 order where this court taxed costs in favor of me and against my ex, and it appearing that my ex's wages are no longer a viable asset. This motion follows, and this motion does not seek any relief from my ex, from the government, and so the government should not be compelled to appear at any debtor's exam or produce any documents or things. I am just making it clear to this court and this judge that I am seeking to collect this money from my ex only, not from the government, and therefore the government should not be forced to appear at any hearings on I guess you could say any hearings supplementary to execution. That's the that's the formal way to explain it. Argument. We have let's see here. I request an order compelling my ex to appear at a debtor's exam. It's been 8 months since she made any payment. I cannot attach my ex's wages because she is no longer working. So at this point in time, she's lost her job. I wonder if I've discussed this before in the other case. I don't know. But I do know that she lost her job right around this point in time, 2015, so it would make sense. I cite the law that entitles me to examine my ex as a judgment debtor. This is the same law that the Court of Appeals is going to use to thump my judge for her order in the FV08 action. So this law here is key. It's key to everything. It's key to all of her mistakes. It's key to why I'm entitled to do what I'm doing, etc. There are a couple of rules of civil procedure. Okay, and these rules discuss the notice of entry of order. The notice of entry of order, not only does it trigger the timeline to file an appeal, but it also is what you have to do to even be allowed to use certain mechanisms to collect on your money judgment. So this particular, in fact, it may be all of them. You may not be allowed to execute on anything until you file and serve the notice of entry of order. That if you want to know for sure, just check Rule 69 and Rule 58 of the Rules of Civil Procedure. It's a good habit to get into. We also have some precedent that I'm citing, which discusses that the Nevada legislature provided for proceedings supplementary to execution, a couple of cases. And I also mentioned that I previously had done this before and it worked. So, I mean, in the past, I have used this process to collect monies from my ex successfully. So it's not a futile, it's a viable sort of approach that I'm taking to collect those monies. I'm requesting an order compelling my ex to produce some documents at least 7 days prior to the date of any examination. And this is bank statements, tax returns, stuff like that. You can ask for all these documents because you can use them at the actual debtor's exam. You can ask questions on them. And there's formally rules in place that allow you to do this. So if you really need to use the formal process, and I actually talk about it right here. If deemed necessary and appropriate by the court, I can reduce this request to a formal NRCP 34 request. Totally viable. And oftentimes the judges don't want you to do that. They don't want you to overcomplicate it. They'll let you just, ask for it in the motion for debtor's exam, and they'll just order your ex to produce it. But if this judge wanted to be a stickler, then I could produce this same exact request under a Rule 34 request. And I think that is everything. Oh yeah, I'm also asking the court for permission to examine my ex through the telephone. The reason why is because I don't actually have to be placed under oath. The judgment creditor asks the questions. The judgment creditor is not answering any questions. The judgment debtor is the one who answers the questions. So the judgment debtor has to be placed under oath, and they're the ones that have to appear in person. So I'm telling the court, hey, I'm not even going to be placed under oath here. Please let me just appear by telephone because my credibility is not under scrutiny. The credibility of my ex is what's under scrutiny. Urging my ex to simply make full payment on the judgment, and upon doing so, I can enter satisfaction in this case and close it out. Of course, she doesn't want to do that because that would end the conflict. Rule 5, Certificate of Service, indicating that this motion was mailed to my ex and the government's lawyer. And a list of exhibits, we have one email. Exhibit 1, here's the email. It is from my ex to me. What is she saying here? Oh, wow, she's telling me that our son doesn't live with her, so she doesn't have to tell me where he's living. I forgot about this, guys. So this is her new argument. As soon as she lost custody, she used that as a new argument to explain why she didn't have to give me her address. So she's like, hey, if I leave Army with somebody, I'll let you know ahead of time. I have no reason to leave him ever, as I don't have a job, and I can spend 100% of my time with him. So as of right now, I wouldn't have a caretaker to list. Since Army doesn't live with me, I don't have to tell you where he's living. So she's like, now that I lost custody, I have a new reason to not tell you where our son lives. And this is all going to come up in a multitude of motions that get filed. Let's see, what else do we have here? Oh, so this is what I'm using to show that she's unemployed. She doesn't have a job. Okay, that's what the purpose of this email is. That makes more sense. That's it. Next document is request for submission. Looks like my ex failed to file a response, and so I just submitted the motion without any responsive papers, and that's the end of that. Rule 5, Certificate of Service, indicating that this document was mailed to my ex and the government's lawyer. If you guys want to know more about what the timelines are and how to deal with them, please watch my video on the topic computation of time. Be fairly warned that those rules changed recently, and so that video is sort of going to give you the idea of what to look at, but it's not a video that you exactly follow to the T. And then the other thing I wanted to mention is in Nevada, the rule that gives you permission to submit a matter without your ex's response is Rule 13. That rule says that if your ex, or any opponent really, doesn't respond within the time limits, then you're just allowed to submit your document without any opposition. Going into the aftermath, I filed 2 documents. The documents were both free filings, so I incurred $0 in costs. My ex didn't file anything, so she incurred $0 in costs. I represented myself in this particular case, so I incurred $0 in attorney fees, and my ex is not participating in this case, so she is incurring $0 in attorney fees as well. The government didn't file anything, so they incurred $0 in costs. The government's attorney, even though they aren't being targeted by this motion, and even though I specifically mentioned in the motion that I don't want them to have to be subjected to any kind of proceedings whatsoever, they still have to at least read the documents to find out that that is my position, and to find out that they don't have to file a response. And so bare minimum, I'm thinking 15 minutes in attorney fees for the government, which at the rate of $250 an hour is going to come to $62.52 in attorney fees. As for my previous videos, if you have any questions, feel free to post them down in the comments below, and I will see you guys next time.